Good afternoon and welcome on in for another edition of From Day One, the afternoon edition, before rainy season, launching tonight at Guild Reset. So this will probably be a quicker version of episode A for today, just because we'll leave more of the items for that time. But in court, we actually get to go back with one of our good old friends, Mike, who says he's got some wild court moments for us this afternoon. Mike, take it away.
Courthouse case of the people versus Ryan Mack.
I'll cover that if Mr. Gaddy's not back yet.
Good morning. Mr. Mack is refusing to come to the courtroom this morning.
Okay. All right. Let's put the appearances on, folks.
Good morning, Your Honor. Elizabeth Andery, Assistant Prosecuting Attorney on behalf of the people.
Honor, Lauren Brown, Deputy Chief Public Defender and potential Lions first round draft choice, appearing written on behalf of me.
then they will still be playing like they are. Okay.
I see Mr. Gaddy's back. We called
He's
Ryan.
the secretary.
Again, no improvement. Courthouse case.
Okay, so we start charming, but don't worry, it gets wackier.
These people versus Xavier.
Going quick. Let's just adjourn it.
Good morning, Your Honor. Amy Reiser on behalf of the people on Xavier Anderson's file.
Good morning, Your Honor. Howard Hawthorne, Public Defender Fellow, requesting permission to appear before the court with and on behalf of Mr. Anderson under Michigan Court Rule 8.120 and the supervision of First Assistant Public Defender Kalina Anderson.
Operation practice is granted. Good morning. All right.
Mr. Anderson is present today. Mr. Anderson, can you state your name for the record?
Xavier Daniel.
Judge, I apologize. Defendant is not dressed.
Okay. You're going to have to get him dressed, and I'll call him back out, but I'm not going to
Mr. Anderson, put some clothes on.
Mr. Anderson, get closed!
I just don't. I had numerous videos where people have done this before. I don't know how they're not getting the memo. I think eventually the judges are going to have to start cracking down and just holding him in contempt immediately for it. But I understand why they don't. I was watching this call. It's huge. They're taking care of a ton of cases. They're very efficient, honestly. But they're going to just have to crack down on this.
And don't forget to hit like and subscribe, or the dogs get it.
If the dogs get it, you get it.
Off. Well, turn your camera off, get dressed.
Courthouse case, people versus Joseph Bailey.
111. Okay. 0111. Thank you. I wouldn't know for the record that. Go ahead. I wouldn't know for the record that we are all fully dressed.
And having seen you, Mr. Brown, thank goodness.
Oh!
Mr. Brown's a bit of a ham, but he's a good attorney. He really does know what he's doing.
All right, what's your next request?
The next request, Your Honor, is that Mr. Bridges is currently on a tether. I believe he's on a scram tether, Your Honor. Mr. Bridges works in construction, Your Honor, and he has to wear work boots as a part of his OSHA requirements. Apparently, the location of the tether on his lower ankle prevents him from being able to wear those work boots on the job site. So I guess he's asking that Your Honor either...
buy him bigger boots?
I think he's asking...
I wish it was that easy.
It's funny you said that because it was exactly what I was thinking.
I didn't hear what he said, but I think he's asking that Your Honor consider another method of testing for him as opposed to the scram tether, and or I don't know if it can be placed on a different part of his body so that it does not interfere with his ability to wear boots, Your Honor.
What I will do is, so that he can work, I'll indicate the defendant may be switched to a SoberLink device. However, I'm specifically indicating two things. One, that instead of the standard 3 that we start with, defendant is going to be tested 6 times a day. They will lay out the time frames upon which he is to test. And then it is further indicated that if the defendant misses a test or misses the window in which he is to test, that will be considered a violation and the defendant is to be immediately remanded.
Thank you very much, Judge.
Thank you.
You understand, Mr. Bridges?
I put this over to the 19th.
Yeah. Do I have to drive to these locations, or how does that? Is that a blow machine?
Oh no, it's going to come with you. But if you don't blow in that device those 6 times within the window provided, it's going to be a violation, and then we will come get you.
That's classic Judge Simpson right there. He's posing as a tough guy, but honestly, he modified it so that the guy could go to work. He ultimately did him a favor, and now all he's saying is, "Don't burn me for it."
Oh, no problem. I'll blow in at any time. No problem.
Thank you.
Thank you, Judge.
Mr. Duzan, are you there? State your name for the record.
My name is Jacob Duzan.
Judge, in this matter, can we set up a Zoom preliminary exam, Your Honor?
You want me to first cancel his bench warrant because he wasn't here?
Yes.
Yeah, that might be helpful.
Yes, Your Honor. I do apologize.
That might be helpful, Your Honor.
I apologize to the court. He lost his phone. That being said, would you cancel the bench warrant and set a preliminary exam?
Mr. Kilowall, did you want to talk about a possible resolution, or is that just the position you're taking as you want an exam?
Well, if you want to adjourn it a week, sure, I'll discuss.
I'll adjourn it 2 weeks out, but he better be here and he better be on time.
I will be.
Am I understood, Mr. Duzan?
Yes, Your Honor.
Probable cause conference will be adjourned May 12th.
Same thing. Looks stern, but he just gave the guy a break and canceled the bench warrant because he didn't appear to court on time.
Thank you. 2022, 9 a.m. Bond continued. I'll cancel the bench warrant.
Thank you.
Court calls the case of these people versus Ian. Is it Pasek?
Okay. Rob Down on behalf of the people.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, paying written on behalf of Mr. Ivan Pechek. Mr. Pechek, if you could state your name for the record.
Your Honor. Say your name.
Other, speak up, sir.
Attorney General Audi Meyerstein.
What? Mike, what did you bring us?
Okay.
I'm sorry. I just really like the way the judge handled that. Okay. You'll see that they find that he's not competent, and we're going back and forth. But you see how they calibrate all of them. These are professionals, and everyone. The judge allows him to sort of talk over him and everything, and he realizes the situation. It's really actually very interesting.
Okay.
Right. In this case, Your Honor, we are set for a competency review hearing. I believe that the court should be in receipt of orders finding that, in receipt of a report indicating that Mr.
Active grounds are not required to enter court.
Indicating that the defendant is not competent.
Active grounds are not required to enter court.
We have no further evidence to present to the court other than
any evidence on behalf of the people.
No, Your Honor, we'll just stipulate to the report.
All right. The court, having reviewed the report, the court would find this defendant at this time is incompetent to stand trial.
Rejected. No, therefore, not required to enter court. Common law, Uniform Code of Military Justice, 10th of March. Presided, acknowledge.
There is, however, reason to believe that this individual may be restored to competency.
That is really interesting to me. Obviously, he looks incompetent, and he's spotting all this stuff, which is clearly sovereign citizen stuff, at least to the extent I can gather what he's saying. He starts with the Attorney General thing, moves to common law, straight sovereign citizen tactics.
Right.
They say that he can be rehabilitated. So the report they have, they says he's currently not competent, but they think he can be rehabilitated. So they have to walk a fine line here. They don't want to dump on somebody who's not competent. And nobody is. They're very professional about it. On the other hand, they don't know if this is a shim-sham or, in the alternative, just something that we can get past and he can get back to it, which is a better outcome for everybody involved. So they're assuming he's not competent and acting accordingly, but he's leaving open the possibility that they can proceed in a normal manner after he's rehabilitated.
In the future. and therefore there's a reasonable likelihood that he can be restored to
Military not required to enter court.
period. The court will then set a
Military not required to enter court. Common law.
court will set a
military justice. Residing at home.
July 28th, 2022 at 9 a.m.
Thank you, Your Honor. It's July 28th.
Thank you. Yes, bond will continue at that. Thank you.
Thank you.
Well, there you have it. Another wild one in Cedric Simpson's courtroom this morning.
Thank you, Mike, very much. We definitely appreciate
Those are just
it.
the things I could grab in the time that
All right. Thank you, Mikey. You've been awesome. And what we're going to do is we'll finish out with the quick fight. Well, we'll take a couple minutes to actually bring a live court case going on. This is some of the hilarious moments of Johnny Depp, of all people, who currently has a court case going on. Just a few minutes, cut down some of the hilarious moments.
Objection calls for hearsay.
Let me ask you a different question, Mr. Depp.
Let's let him object to another one. Had a conversation with Ms. Hurd.
Let's move beyond the prior stage to that and show you where we had business.
Said, yes, they have. It was in Ms. Hurd that told hearsay.
God damn it.
She would like for him to croak. That's hearsay, I guess.
I know, I'm just curious on the truth of the matter, sir.
He got it.
Okay, all right, well,
I'm learning. Ms. Hurd, that
I'll move to strike this as hearsay, Your Honor.
disturbing. Yes, I looked at papers. Maybe they're hearsay.
Maybe they're hearsay papers.
Someone's article, not from the man's mouth.
It's a pretty simple yes or no question, which is
You'd like
other
to be correct.
others
Nothing simple. October is 2 months before December. That's correct.
the document that you signed as part of your divorce proceedings, correct?
That's my signature indeed.
That is your signature on the right, correct?
Yes, it is.
It's the document you signed, right?
For the third time, that is my signature, yes.
And that was a document you signed in August of 2016. Correct.
Is that the same one that I signed 3 times before?
Yeah, well, I wanted to make clear that you signed that in the summer to Paul Bettany, correct?
Again.
Okay. So you were drinking pretty heavily.
Were you there? The ugly situation with Amber.
Mr. Depp, with respect, trying to respect the court's time and the jury's time, that was not my question. My question was simply, you would agree that on Exhibit 500. 500. That's Exhibit 500.
You'd like to see who I lied to.
I was drinking whiskey in the mornings too, right?
Isn't happy hour anytime?
Drink cocaine in that box?
No, but it looks like it would fit some cocaine. Just gave Marilyn Manson a pill so that he would stop talking so much.
Not right.
You did.
Did I read that correctly?
You did.
Okay. Did I read that right?
Yes, you did.
Did I read that right?
You continue to read them right, yes.
Right after you cut your finger off, right after, I won't give you anything to argue with me yet. Right after you sustained an injury to your finger, poured yourself a mega pint of red wine, correct?
A mega pint?
Yeah. Fast forward in time a little bit, Mr. Depp.
Yes, I can feel it.
I have other uses for your throat which do not include injury. I have other uses for your throat which do not include injury.
Sorry, could you read that again?
And that was just a couple minutes of interviews, testimony against Johnny Depp. Actually, looks like we got a little bit more, so we got a moment while we finish fight. So let's do a little more Depp.
You heard Miss Heard say, "Get off me," right?
No, I did not. Hitting the wall hard based on the accusations that she brought. I'm sorry, I was talking. Is that all right?
You'd answer my question. We'll take a look at the next one. Thank you.
As long as you're happy, sir.
You didn't want her out. You wanted to control her career, correct?
Objection compound.
Let's
Hold on,
Mr.
Depp. All right, yes, I'll sustain the objection. Next question.
We can, do I read that right?
Yes, Mr. Rodmore.
Oh, we're back to that again.
You're complaining about her ambition in this text to her. To Dr. Kipper, correct?
I'm realizing that her ambition is far stronger than her supposed feelings for me, yes. It doesn't mean that I actually literally cut my finger off after, at the age of 12, finding the only thing that gave me peace, which is playing the guitar. Very unlikely. Why didn't I start lopping off digits when I was 13?
Just the way it was worded. Now, Miss Heard what?
Objection relevance.
When your nerves are
Sure, can we approach her? She was trying to get you to stop using drugs. But let's take a look at what you say in this text.
That term before.
In this text, Mr. Depp, you say there were numerous negative news stories about you. You agree with that, correct?
Objection compound. That's the state's compound.
Thank you so much.
May 7th, 2016. It's entitled Johnny Depp. Friends and family seriously concerned about him. Here's why.
Yes, how did they know?
The next article, from May 1st, 2017, before Miss Heard filed says, Johnny Depp reportedly drank heavily and was constantly late on a new Pirates movie set. Did I read that right?
You did, reportedly.
The next article, also from May 10th, 2017. Mr. Depp,
this is a pathetic attempt.
Mr. Depp, please just respond to the question I'm asking.
What's your
the next question, the next document is entitled Johnny Depp's financial woes might sink the next Pirates of the Caribbean. Did I read that right?
You did, I don't know.
The next article, May 25th, 2007. Johnny Depp's star power looks as wobbly as Jack Sparrow on a plane. Did I read that right?
You read that very, very well.
The next one, Hollywood Reporter, May 27th, 2000. Did I read that correct?
This is hearsay.
June 21st, 2018, 6 months before the Inside the Trials of Johnny Depp. Did I read that right?
You did. You should read the article.
And the last one, June 22nd, 2018. Alison Boshoff reveals why Hollywood's reeling over what's being called Johnny Depp's career. Did I read that correctly?
You did. Who's Alison Boshoff and how does she know?
Mr. Depp, you can't name a single actress. No further questions.
Ladies and gentlemen, while we go ahead and take our morning recess for 15 minutes. No.
Sean Bailey, who was the number 3.
Objection, hearsay.
I don't know yet. A rule at this point.
Continue.
Yes, sir.
Just basically said in the
objection, hearsay.
Your Honor, this is about him learning about this. It's not for the truth.
It is the truth.
Mr. Depp, would you please explain to the jury who Sean Bailey is? I think we're starting to.
Yes, I'll try again. Sean Bailey was quoted as saying that...
Objection, hearsay.
Mr. Depp, where was Sean Bailey quoted? without getting into what he was quoted as saying.
I don't know who did the interview with him.
Objection, Latin Foundation.
Open objection. Mr. Depp,
I've been approached to take part in writing
Objection,
Paragraph
hearsay.
6.
last week Mr. Rottenborn asked you about a quote where you said you wouldn't come back to the Pirates franchise for $300 million and a million alpacas. Do you remember that?
I do.
What? Do you recall when specifically you made that statement about the $300 million and the 100 alpacas?
Objection.
Mr. Duff, do you recognize this document?
As soon as my eyes go on, I'll go for a look. I'm so pathetic when it comes to knowing what movies I've done. I'm sorry. I don't watch them. I feel better not watching. I couldn't. What was the question again?
How many?
I have order in the court, or I will have you removed. Understood?
How would you describe Mr. Bettany's relationship with Miss Heard while you and Miss Heard were together?
Abominable.
Mr. Depp, I believe this is another text message with Mr. Bettany that you were shown on your cross-examination.
And when he came home from school,
I'm just going to check.
We can move on.
Okay.
Mr. Depp, what if any portion of this email exchange is literally true?
we're all set to leave here at approximately 1:30 p.m. Hope you rest as well.
That is good.
There's also a napkin down there where someone what?
I have no idea whether they exist. You didn't know what could cause damage to Mr. Depp's hand while you were there on March 8th, correct?
Dr. Kepler told me he sustained an injury on one of his fingers.
Objection, hearsay.
You can't object to your own question.
Injury to his finger.
One of his fingers.
Objection, hearsay. Okay, you said he sustained an injury?
And with that, we will bring to a close today's part 1. Part A, as the saying goes. Of course, come back for the frauditors, auditors, substance, and B, and of course, Art Bell in the overnight. Till then, please like, share, and subscribe. Be kind to one another, and release the Krakens. As we continue to march along here from day 1. Have a great afternoon. We'll see you tonight.